The case of the unpaid lawyer. What was the agreement between the lawyer and her client?
What do you mean by further compensation? Further beyond what?
Beyond any legal representation that was going to occur after that date.
After
the September 17th date.
Okay.
It hadn't gone to trial yet.
Oh, I see.
So
Okay, I understand. So this I was mistaken. It wasn't signed 2 or 3 weeks later. It was signed a year later. Okay. So
I represented her at trial, and it did go to trial. I didn't drop out. We went through a trial. A judgment was awarded. The judge awarded her monetary damages in lieu of awarding her title.
So it sounds to me as if sometime in 2002, maybe the end of 2001, things didn't quite go the way you thought it would go.
She thought it was just all going to happen quicker, and
Right.
she should have title, no matter what. And this was.
And so the attorney-client relationship kind of broke down a little bit. Relationship deteriorated, and so you signed the subsequent retainer
Right.
agreement a year later,
Right.
saying that, all right, I'm not entitled to any more money, but I'm going to get paid for what I was for the work that I previously did, and I'm only entitled to more money if I get you title.
Right. That's right, Your Honor.
And the statement of services show work done prior to September 17th, 2002.
That's correct. I did not ask for any compensation after the date that agreement was signed, and she was not awarded title, which was the deal I made.
Ms. Garners, I'm having trouble understanding your defense, quite honestly. You signed an agreement for Ms. Sabraka to represent you, to quiet title, apparently was to do a partition action. You agreed to pay her $135 an hour to do it. There doesn't seem to be any dispute about that. And at some point, you signed another agreement a year later, September 17th, 2002, saying that she's not entitled to any additional money unless you get title to the property. Now, you didn't get title to the property, so I guess she isn't entitled to anything after September 17th, 2002. But what about before that?
Before that is vague.
What's vague about it?
Vague because of the fact she said she would notify me to let me know how much time she would put in, okay? And then I would pay, okay? And then she asked for a retainer for more money the second time, so I gave her more money the second time.
Before September 17th, 2002, still, right?
Correct. And she said I was paid up in full, okay? So
Okay.
we did not, there was a lack of communication between us, okay? It was unknown to me at that time that I owed her money.
You know
Okay,
now.
I'm thinking I was paid up in full.
Okay, but you're not.
But all this time had gone by, okay?
So why does that make the bill not due? You know, if I have a credit card and I don't pay for 5 years, the company doesn't forgive that. You still have to pay it. I just don't understand the defense here, because it appears the work was done. You're not really contesting that the work was done. You're somehow saying that maybe you received the bill too late and you shouldn't have to pay it.
I'm not satisfied with the judgment.
Okay, but that doesn't mean that you don't have to pay.
But I made her aware that I was unsatisfied with the judgment, and she went ahead and signed it. She signed for the judgment, okay, which I did not agree to, okay? And then, you're right, there was a lack of communication. Her and I weren't really seeing each other eye to eye anymore. She wanted out. She didn't post for judgment. She just signed accepting it and said, I wanted out. Okay, so she didn't get the judgment after it was awarded by the court. She just quit.
Well, from what I'm seeing, the defendant is correct. There was a lack of communication between the attorney and the client. The problem, a lack of communication is not a legal defense when the retainer or contract is clear. Let's see how the judge decides.
An attorney has an obligation to zealously represent clients. If there's an attorney-client breakdown where the attorney can no longer zealously represent a client, the attorney has an obligation to withdraw from the case and no longer represent the client. And if, as I said, something went wrong between the two of you, where Ms. Zabraka felt that she couldn't have your full interests at heart, then it was probably the right thing for her to withdraw from the case and no longer represent you, because that she couldn't represent you zealously, as she's obligated to do under the ethical rules. But that really isn't what this case is all about. You know, Ms. Gonars, when you retain an attorney to represent you, particularly in litigation, you never really know what's going to happen. Litigation is a very strange, complicated thing that contains many twists and turns that can't be predicted early on. And what you do is you agree to pay an attorney an hourly rate to represent you in that litigation, and in this case, that was $135 an hour. And however the case goes, that's how it goes. And you've got to pay based upon the time that the attorney puts into the case. And many, many times, the case doesn't go the way you think it's going to go or the way the lawyer thinks it's going to go, because that's the nature of litigation. That's the nature of court proceedings. Surprises come up. Things happen that we don't know about. And you have to pay for the time that the attorney puts in on the case to resolve that case, to litigate the case, to try the case, even though it may not be the way you think it is. And that's, I think, what happened in this case. There's nothing here that you're telling me that indicates Ms. Zabraka didn't do what she was supposed to do. She was supposed to retain you, or she was supposed to represent you in a quiet title action, which she did. There's nothing here to indicate that she didn't do that. There's nothing to indicate that her services were not at the level that they should be for an attorney of her expertise. There's nothing here to indicate that she's billing for services that she didn't do, services that were not rendered. And so I think you ought to pay it. Ms. Zabraka represented you. Now, maybe the case didn't go exactly the way you thought it should have gone, but that's not what this case is all about. That's not really the legal issue. So I'm going to enter a judgment in favor of the plaintiff, Ms. Zabraka. I do have a question about your cost, Ms. Zabraka. You said $88?
Yes, Your Honor.
I have a $45 filing fee, a $21 service fee, and a $20 motion fee, which, if my arithmetic is correct, is $86.
Okay, I was wrong on the filing fee.
All right. The court then will enter a judgment in favor of the plaintiff, as I indicated, in the amount of $1,327.37. The court is going to also add to that costs consisting of a $45 filing fee, a $21 service fee, a $20 motion fee, bringing the total amount of the judgment to $1,413.37. And that'll conclude this hearing. Ms. Zabraka, I'll give you back these two items over here.
Thank you, Your Honor.
Okay, you can have a good day.
So even though the client was not happy with the result of her land case, she still has to pay her attorney. Why? Because the client signed a retainer, an hourly retainer, where the client agreed to pay the lawyer $135 an hour, win or lose. We'll be back in a moment.